actually some cattle nations
Your daughter's liking. She's liking a lot. Came around. Good. It's Dr. Parker's is she freshman?
Yeah.
Sophomore now.
That's gonna be
classic this year. Okay. That's good. She's enjoying it. Because
Oh,
I'm on leave. I mean, I might
Oh,
pick it
okay.
back up at some point in time, but not right
So
now.
they're okay.
Welcome
Okay, so they still
to
got them.
Yeah, yeah, like, I kind of got a foot in the door, which is nice. 'Cause I was really happy that they let
My
me
name
do
is
that.
Tom Fitzpatrick.
It was one of the benefits of taking that particular job when I did was that I knew that it had some flexibility for allowing me to run, and if I didn't get it, then great, and if I did, then maybe I had an opportunity to take leave.
series. And before we get underway, I'd like to invite Mr. Farmer to provide our blessing. This team is a charity and everything member here in the Native American Studies Department. Good. I'm going to ask you to stand, please. Oh, you.
Viitattiin Halessa heti. Lähessä kehänä esiin. Tänne jomni tuohon tintekosti. Heillä kalokti non ha tin steriski tintekosti. Ijali evicinat dan degni gohila. Nihi chikaviena. Ta gohusto gina laski en hija teose. Gohust min hohila iski. Ohi teose. Halesko hena dan de Australian, Halakali Australian. Geloofsko niskian, so viela op het steek. Halesko hena, again net dos getaken in dohes. Cijelo Gadis, School Gots.
The Office of Tribal Relations, in collaboration with the Center for Faculty Excellence, welcomes you to today's keynote featuring Comanche Nation Chairman Todd Wanipa, who will provide a tribal leader's perspective on ethical engagement in tribal treaties and tribal treaty rights. To introduce him, it's my pleasure to introduce Dustin Hamakara. He is the Whit Carey Endowed Chair of Native American Cultural Studies here at the University of Oklahoma. And he's a proud Comanche Nation citizen and an accomplished playwright, performer, and scholar. His work focuses on Indigenous media, sound, and cultural storytelling. He has written 2 books entitled Tribal Television and Cinematic Comanches, Exploring Native Representation in Media. In addition, as a cultural advisor for the film Prey, he contributed to authentic Indigenous representation. Currently, he is a Generation Now playwriting fellow, developing works like Comanche Girl on the Moon. Dr. Tamakara's contributions enrich the intersections of Indigenous identity, history, and future narratives. Please join me in welcoming him.
In the Namatekwa, in the Comanche language, I say ha, Madoika, ha, Aitzna. Nanani sa Dustin Tamakara, Nasa Namana, Nasa Taibo. Good day to you all. Sat, Sadina. Madoe, right, as I was just saying, because there's more than one of you in the room, Madoika, is our closest word for hello. But as my late auntie, Juanita Pataponi, explained to me years ago, it means to report back to the people. To enact Madoe here today is to report to you about today's featured speaker, Forrest Patanipa. Back in the day, I remember hearing about Forrest as a champion cross-country runner who literally went cross-country, across Indian country, to compete at Stanford University. There, he also received a degree with honors in public policy, then went across Indian country back to Minnesota, where he earned his JD degree at the University of Minnesota Law School and graduated at the top of his class. Since then, he's worked for the U.S. District Court, Minnesota, the Minneapolis City Attorney's Office, served as president of the Minnesota American Indian Bar Association, and served on its board of directors, while also frequently returning home to Comanche country in our jurisdiction, our shared jurisdiction of Southwest Oklahoma. I think that's all Kai was, so I added shared jurisdiction. You get in trouble. And returning back to our shared jurisdiction of Southwest Oklahoma for family, for tribe. He also became a partner, finding time somewhere along the way, finding time to become a partner at the international law firm, Dorsey and Whitney, practicing in the area of Native American law. All of which has prepared him for his recently elected position in May of this year as chairman of the Comanche Nation, specifically chairman of our Comanche Tribal Council and our CBC, Comanche Business Committee. Grounded in tribal culture and tribal law, Chairman Tadanipa's life passion is in practicing Native law and protecting, strengthening, and educating others in tribal sovereignty. His priorities in office right now include strengthening the faith and the trust that we as Comanches have in our government, reforming our Comanche Constitution, and establishing a tribal law charitable foundation for cultural preservation and continuity. Prior to being elected earlier this year in May, Chairman Tadanipa was an associate professor of law at Digital Hamline School of Law, where his legal scholarship focused on the intersection between religious freedom and intellectual property. He taught such courses as civil dispute resolution, pretrial litigation, Native law, and Indigenous cultural and intellectual property. And this afternoon, Chairman Tadanipa continues this good work of educating, of bridge building, and of generosity here at OU with his keynote talk entitled Treaties and Treaty Rights, a Tribal Leader's Perspective. So please join me in welcoming Chairman Forrest Tadanipa.
All right. Redato Heights, Safu. Appreciate the introduction from Dr. Tamakera, Adalweka, everybody. You know who I am, so I'll kind of try to fast forward through this first little bit here. But the one point I did want to make with this first slide was just that I am a lawyer, as you heard, by training. I guess what they call me now is a recovering lawyer because I'm not currently practicing law. But what a lot of this is going to go over is sort of the law and kind of what I view as problems with the law. So it's going to be heavily focused on the law because that's kind of my training and my bias. But I have been a tribal elected official now for almost 6 months, so I'm still relatively new to it. But even in that kind of short time, I've kind of noticed a few little things, I guess you might call them pet peeves, about how the rest of the world views tribes and views tribal sovereignty. And so I'm going to kind of try to explain what those are. And in particular, one of them I see all the time is kind of this view that treaties are special treatment, or treaty rights are somehow some sort of preferential treatment, which I guess in a very strict technical sense is true because treaty rights are unique to the members of the tribes. But when they're called special treatment, I think that kind of has this connotation that it's some type of reverse discrimination against people that are not tribal members. And so what I want to focus on mostly is kind of disabusing that notion from anyone that happens to have it, and focusing on what treaties mean to me as a tribal member, as an elected official. And what they mean to me really is it's our treaty rights are our birthright that we inherited from our ancestors that literally gave their lives. They died, they were injured, they were killed, they were massacred, so we could have these treaties. And so that is, obviously putting them of a level of importance way up here. And so that's why I'm going to critique some of the law that exists around treaties, because I think when you talk about the law, you kind of put them here. And so we talk about them being the sacrifice of people that died, I put them up here. So that's basically what I want to talk about. And to get there, I'm going to talk about some of the history of our current treaty, and the Comanche Nation's current treaty is the first treaty of Medicine Lodge Creek. I want to try my best to kind of focus on the Comanche story, because that's probably, to the extent I'm qualified to talk about anything, that's what I'm sort of qualified to talk about. But it's impossible to talk about this treaty without talking about the Kiowa tribe also, because they are also signatories to the same treaty. And it's impossible to talk about this treaty without talking about the Apache tribe of Oklahoma, because they signed second treaty of Medicine Lodge Creek the same exact day, which brought them into the first treaty of Medicine Lodge Creek. And then it's also impossible to talk about this story without also talking about the Southern Cheyenne and Arapaho tribes who signed a treaty 7 days later at Medicine Lodge Creek. So this is, all of these Southern Plains tribes, our histories are intertwined. And so I'm just kind of giving that as a kind of long apology to any Kiowas, Apache, Cheyennes, or Arapahos in here if I get any portion of the story wrong from your perspective. But the focus of the reason I want to focus on the sacrifice of people, the sacrifice of our warriors that literally fought for these treaties, is because I think it kind of restylizes how we look at treaties, and what the consequence is, I think, is it puts some new light on what we call the trust relationship. And so I don't know, maybe some of you have heard of the trust relationship. Certainly if you're native, I'm sure you have heard of the trust relationship, but if you are, just coming in from the faculty or staff, and this is kind of area Native American law is new to you, then the trust relationship might be a new term, but it is something that exists. It describes the relationship between tribes and the federal government. And I think when we look at treaties as the result of these hard-fought wars, that sheds a lot of new light on the trust relationship. And I think that has a lot of consequences for how we view the way that things should be versus how the way things are. And when I say that, I'm talking about things like the relationship between the state and the tribes, or the relationship between the federal government and the tribes. There's supposed to be this trust relationship, but I think too often it kind of becomes a sort of thing of lip service rather than an actual meaningful description of what the relationship is. So again, that's kind of what I'm going to talk about. That's a little bit of a teaser. I hope to explain all of that very clearly by the time we get done with this, but if I don't and you have questions, if someone has a burning question, you can just shoot your hand up and I'll do my best to try to call on you. Oh, wrong way. All right, so the most common starting point that I see from both lawyers and non-lawyers when it comes to talking about treaties is to talk about the US Constitution and how treaties are the supreme law of the land. And that comes from this particular clause in the Constitution. This is a super famous part of the Constitution. If you were to look it up, you would see that it has a technical name, and that technical name is the Supremacy Clause. And it is a very famous part of the Constitution because it is the basis for what we call preemption. But it is always pointed to, or not always, but I think most frequently pointed to when people want to start a conversation about treaties to say, look, the US Constitution says that all treaties made shall be the supreme law of the land. And that's where people like to start. And it has its benefits for sure, because I think the reason they focus on that is that there's a lot of rhetorical punch that you get from saying the word supreme, right? Like the word supreme, that sounds very impressive, and you get a lot of push from that. I think another reason that people like to start here is because it really emphasizes the government to government relationship that's supposed to exist between tribes and the federal government. Because what are treaties? Treaties are bilateral agreements between two sovereign entities. So if you start with the Supremacy Clause, then you are starting at a point where you're saying, look, the Constitution says this is supreme, which is powerful rhetorically, and also what are treaties inherently, but they are between two nations. And so because the United States entered into treaties with tribes, they were admitting, they were conceding that tribes are nations and they have that sort of status. They have the same status as France or Mexico or, you know, whichever country you want to pick. So that is why people start there. And I don't want to be too critical because I think all of those things are good. But I don't like starting from the Supremacy Clause because first and foremost, you are starting with this conceding the legitimacy of the US Constitution in the first place. You are playing on the field of Western laws. And so you're giving right away the home field advantage to dominant society, to America, to the, you know, the entire colonial system, but you're saying we're accepting their constitution and what it says as legitimate. And so I don't want to concede it's the legitimacy of Western colonial laws at all, because I think once you do that, then we start to over legalize treaties. And what do I mean by that? Well, we start to look at them like contracts. And I think that has a few bad consequences, because if you look at a treaty like a contract, then you're going to start to interpret it like a contract. And I think if you read decisions from Justice Kavanaugh, for example, you'll see that he really does this a lot. And his opinions are always very much against tribes and against tribal interests. Because when you start reading this as a contract, then you're going to start saying, what does this language mean as I read it in 2024, sitting in my office, versus what did this language mean in 1867 or in 1858 or in 1829 or whenever this treaty was from? What did the language mean? What was the context historically surrounding this language? And if you take it in a vacuum, you can come to a very bad result, rather than if you look at it, I think, from the actual context, and you can come to a very different result. And I think further that once you start looking at a treaty like a contract, you run into the fact that contracts can be broken. So what's the consequence for treaties is that treaties can be abrogated. And there are a lot of treaties that can be abrogated, right? Like that is something that is just within the power of the United States. Like I have this kind of old example here. The Jay Treaty of 1794 was between the United States and Great Britain. And then they went to war 18 years later in the War of 1812. And that ended the Jay Treaty from the perspective of the United States, because they just had this battle and this war, and then they got a whole new treaty, the Treaty of Ghent. And I'm sure there was further treaties with Great Britain since then. So they can always end a treaty kind of in a more modern context. We just had an election, and who knows what President Trump will want to do with a lot of the treaties, but we have things like the North American Free Trade Agreement, just supposed to have free trade between the United States and Mexico. He's been talking a lot about putting on tariffs, so maybe we'll start to get out of some of our free trade treaties so we can start putting tariffs on. And it's all this very technical kind of legal sense or legal talk, where if it's just a contract, you can just breach a contract, you can get out of a contract, just pay some damages, or just rewrite it, or whatever. And I think it really does a disservice to what a treaty right should be, because I think when you talk about a right, like a human right or a fundamental right, that is very, very different in terms of importance versus if you talk about like, this is my obligation under a contract, right? Like we don't put our contracts on the same footing that we put human rights. And I think we need to look at treaty rights more like human rights versus looking at them just like these sort of, contractual obligations that are owed by the United States to tribes. The law kind of has anticipated a lot of this. And so there's these things called the canons of construction that exist that the Supreme Court is supposed to use to interpret treaties and look at how Native Americans would have understood them at the time they were signing them. But I think we've gotten very far away from that. And so that's why I want to reemphasize that in my presentation right now. I think we've just gotten very far away from trying to look at treaties of how they would have been understood at the time in favor of just looking at the treaty kind of in a vacuum. And I think especially with law trained judges, we've all, as lawyers, we all get indoctrinated in law school to look at things in a certain way. And so judges are not immune from that. And everyone here, we're all trying to do a good thing, go to school, get our education, but sometimes you become hyper focused on the words on a page and you forget to look up and look all around at everything else that happened. And so that's what I think we should do. And so to do that, I think we should look at a little bit of the history, and especially because the thing that I think we should not do and the things that we should resist is finding this sort of abrogation of treaties. Just say, oh, it's just like a contract. You can just break a contract. It's just like any other treaty, like a treaty with France. We can break a treaty with France. And I don't think we can or should look at Indian treaties the same way, because Indian treaties are sui generis in that they are creating that trust relationship that I mentioned before. And specifically, Indian treaties, for the most part, and the Treaty of Medicine Lodge Creek in particular, is coming from a context where you had warring adversaries and the tribes and all of their warriors said, we are setting down all of our weapons and we are surrendering our right to self-defense. And you are supposed to, the United States, now protect us. And that's the fundamental part of the trust relationship, is that the warriors gave up their right to fight. And when they did that, the United States was supposed to become this protector. And that is very different from entering into a treaty like the Jay Treaty, where Great Britain could go to war with the United States 18 years later. Tribes now today do not have the ability to go and wage war against the United States the way that they did in 1867. And the consequence of that is that trust relationship needs to be taken more seriously, in my opinion. So, Treaty of Medicine Lodge Creek is what I wanted to talk about. It's the last treaty that was signed with the Comanche Nation. It was October 21st, 1867. As I mentioned before, the Kiowas were also signatories. Later that day, the Apache tribe signed another treaty to confederate with the Kiowas and Comanches. And then a week later, the Cheyenne and Arapaho signed a treaty as well. Medicine Lodge Creek itself is just north of the Oklahoma border in Kansas. And that was really the fundamental reason that they were even signing these treaties, all of these different tribes, was because the United States was trying to remove all tribes from that part of Kansas, because there had been a significant amount of conflict and war in that part of Kansas, western Kansas and eastern Colorado. And then as it concerns the Comanches specifically, there had been a significant amount of conflict in Texas. And so the government was also trying to remove Comanches, Kiowas, Arapahoes, and Cheyennes from Texas and the Texas Panhandle. there had been centuries of encroachment by Europeans into Comanche land. In English, when we talk about Comanche land, sometimes they use a Spanish word, ironically enough, Comancheria. In Comanche, you know, we got our word for it. My older brother's here, so it makes me nervous to talk Comanche because he talks better Comanche than me. So, but Namasokovi is how you would say, you know, our Comanche land in Comanche. And then the Spanish called it Comancheria. And so in English, we use the Spanish terminology for whatever reason. So there have been, you know, centuries of encroachment by Europeans into Comancheria. And so I can't go through the entire history. Obviously, we don't have time for that because that would probably be like a semester's long class, right? So I'm just going to really have a very abbreviated history of the leading up to the Medicine Lodge Creek Treaty, like really just talking about the year or two prior to it. But I didn't want to do a disservice to anyone, right? So I wanted to point out that there were these centuries of conflicts. And one thing I wanted to point out too was that the Comanches actually entered into some treaties with Spain in the 1780s. In 1785, there was a Spanish delegation that went to Texas and entered into treaties with the eastern bands of Comanches. And at the same time, the following year, they went into New Mexico and they entered into treaties with the western bands of Comanches. And these treaties preserved peace for a long time, largely, and they largely also respected Comanche territory and limited the amount of settlement by Europeans that was coming in to Comancheria. And that all kind of fell apart with international politics when Texas seceded. Well, first, Mexico declared independence from Spain, was the first big event. And then Texas seceded from Mexico and then ultimately joined the United States. So all that chain of international politics led to a lot of European immigration into the area. In the 1820s and 1830s, after Mexico got its independence from Spain, they were encouraging a lot of immigration into that area, which led to a lot of encroachment into the southern part of Comanche territory. Then Texas succeeds. It eventually joins the United States. And there is a lot of gold rushes that are happening in Colorado, in the West Coast, in California, and that's leading to a lot of use of the Santa Fe Trail, which is leading to a lot of encroachment on the northern part of the Comancheria, especially when with all that increased traffic, there comes more permanent settlements. And so that is kind of setting the stage. There's all this new immigration and settlement of Europeans into Comanche country. And so then there is conflict. And so there's so much conflict, and it's kind of become just a general lore of the United States, right? Like that's why they make Western movies about Comanches and Kiowas and Apaches and Cheyennes and Arapahoes, because there was so much conflict, it just became part of the lore of like, that's, you know, you go in the frontiers, there's conflict. The movie The Searchers is about that. It's supposed to be the #1 Western rated. And there's a book that's about the same exact story of The Searchers, Empire of the Summer Moon. I guess they're making a movie about that, maybe two. So that's all about one specific story, but it's so deeply ingrained that it's kind of just become the general story of the frontier. There's a couple big conflicts that I thought were just interesting. I always just find interesting. So this is kind of just a rabbit trail to the side. But I always found the fact that there was this thing called the Great Raid of 1840 to just be kind of interesting and significant. So this is the largest raid in the history of the United States. And it was a result of the Council House Massacre in San Antonio, where 30-something peace chiefs of the Comanches were massacred by the Texans. And in retaliation, the Comanches went all the way to the Gulf Coast, Linville, Texas. It's like just outside of Houston, and sacked an entire town, burned another entire town to the ground, and then came all the way back to West Texas. So I just always thought that was kind of interesting and cool. But there was all these other treaties that resulted from these, right? And we don't have the time to go into all these other treaties or talk about all these other things. But again, I just didn't want to do a disservice by omitting them. So I'm just kind of glossing over them. Unfortunately, we just don't have the time. So with the stage set, the 1850s, all of this new immigration coming in, and these settlements, there's all of this increased conflict, especially when there's the Civil War, which causes there to be fewer or less of a military presence by the United States. That leads to, increasing conflict between settlers and the tribes in the area. And one particular battle that I want to highlight, because it comes just a couple years, just 1 year before a treaty of 1865. There's a treaty in 1865, and then there's a treaty in 1867. So what I'm talking about, I want to talk about, focus on, is the first Battle of Adobe Walls, which is in 1864. So this is 3 years before the Medicine Lodge Treaty, and 1 year before what they call the Little Arkansas Treaty. So this is the battle I want to focus on, and tell the story a little bit about it. And one of the reasons I want to focus on it is just because temporally, like, this is the big battle that led to these treaties, right? Like, this is the impetus behind the United States wanting to sign these treaties. But I also think it is very illustrative of the sacrifice that the people that fought this battle made, because you had the army coming into Comancheria. This was what they called a punitive expedition, and it was led by Kit Carson. If you're Navajo, you probably know who Kit Carson is, right? Like, famous Indian fighter. And he came from New Mexico with a few hundred enlisted men, a dozen officers, and some Indian scouts. But the significant thing that he came with was he came with these howitzers. And this is a picture, that's why I have this up here. This is the only picture I have in my presentation, because I just wanted it to illustrate what these people were up against, what these men, these warriors of these tribes were up against, is that they were up against this artillery. And they had bows and arrows, they might have had some rifles, a couple of them might have had revolvers, but the military comes into their winter encampments with two of these that can fire a 9-pound shell 1,000 yards. And this is not a specific, this is the model. I don't know, it's not the exact ones they had, right? This is from like a museum, but this is just to illustrate basically what they would have looked like when you had, again, men on horseback that had to fight against howitzers like this. And so to me, this is what this treaty means. The treaties that were entered into after this represent the bravery of warriors from these tribes that had so much courage and so much desire to protect their men, women, their women and children and their elders, that they would ride a horseback up in front of this when this thing can blast a 9-pound shell 1,000 yards. So, as I said, Kit Carson brings two of these in to the winter encampments, 1864, November. This is in the Texas Panhandle. They find a Kiowa village and they attack it. Again, they're attacking it. They're not, they're attacking it, and they're attacking it with these. And some of them escape, go and they spread word to nearby Comanche villages. And they all summon all the warriors and they counterattack with 1,000 men. Again, 1,000 men that have the bravery to go and charge up against these howitzers to defend their women, children, and elders. And this was further kind of a battle that was kind of further made famous by the fact that there was a Kiowa chief, Satanta, who had a bugle, which I believe is still in possession of the Kiowa today, and he used it to confuse the calls of the buglers of the army. So it was a very kind of shrewd military tactic that they used. And so this is a victory from my perspective for the Native Americans, because they use this bugle, they confuse their attack, and they actually get Kit Carson, this famous Indian fighter, who's not, it's not a fair fight, right? He's armed with two of these, and he's got all these men, and he's got these officers, he's got all these scouts, and yet they are able to repel him and remove him from their area. So to me, this is a just awesome victory of the allied Comanche, Kiowa, and Apache warriors here. It is, when you read through some of the historical records, counted by the US military as a victory for themselves. And I don't know how or why they can say that they won a fight that they retreated from when they had these two huge cannons against all these, you know, some guys on horseback with bows and arrows and rifles. But that's how they count it, you know, that's the story that they tell. But the story that I'm telling is that, and I think the story that is recorded, like if you look at all the oral tradition and then the written history, like the Kiowa calendar for that year, the Kiowa Comanche Apache, we considered this a victory for ourselves because we got kicked Carson out of the Texas Panhandle. And if you read some of the history books, they will admit that this was like a hair away from being the Battle of the Little Bighorn. And it was that close because they almost wiped out Kit Carson and all of his men, because they almost trapped him in by lighting a fire. But Kit Carson used a backfire and just narrowly escaped. But it was a hair away from being the first iteration of what happened at the Battle of Little Bighorn. So to me, this was a definitive victory for the Kiowa, Comanche, and Apache against all odds, against these, again, against these howitzers, right? So this directly leads to the Treaty of Little Arkansas. And this is the Comanches part of the story, but I would be remiss, like again, I don't want to like tell a story that's mine, not mine. I also don't want to gloss over things too much, but I also just don't want to omit things. So it would kind of be dishonest if I just omitted the fact that the same day that the Kiowa Comanche signed a treaty, the Cheyenne and Arapaho also signed a treaty, and the Apache in 1867, they actually signed with the Kiowas to join the Kiowa Comanches. But then in 1865, they actually signed with the Arapahoes because they wanted to join the Cheyennes and Arapahoes. So it would be remiss of me if I didn't mention what happened to the Cheyenne and Arapaho a few days after this battle, which if you're Cheyenne or Arapaho, November 1864 might have significance to you because that was the Sand Creek Massacre. So I just want to mention that out of due respect to what happened there. And there are actually some of our folks too, Comanches, that come from this Sand Creek Massacre too. Some of our families through intermarriage, there was some Arapahoes that had half Comanche children, and some of those children went back to the Comanches after this massacre. So some of our families too also are survivors of the Sand Creek Massacre. But what happened here, you had, again, this conflict is happening in Kansas and Colorado and Texas. In the Colorado portion of this conflict, you have this governor that issues this order, this proclamation in the summer of 1864, and says, any Colorado citizen is authorized to kill and destroy as enemies of the country, wherever they may be found, all such hostile Indians. And so I think a lot of times when we have discussions around Native American history, there's kind of like this mention of, you know, scalp bounties or massacres or atrocities. And I think, in my personal opinion, sometimes things kind of get glossed over. We don't sit and dwell on like, how did this happen? And so I think having the actual language of some of these things is very powerful. Like when I was teaching law school on day one, you know, we'd always go over the doctrine of discovery. And I thought it was very powerful to actually put up on the screen some of those papal bulls that talked about, you know, conquering the savages and blah, blah, blah. So here we have it, like the governor saying, if you find an Indian, you can kill and destroy them. And further, as a reward, the governor will authorize you and empower you to hold to their own private use and benefit all the property of said hostile Indians. So again, black and white, you can see if you are a Native American and you are not in a specific spot, that's what it says when it says here, call the rendezvous at the points indicated. So the first paragraph, this is just an excerpt, but the first paragraph had these specific places that people were supposed to go. And if you weren't at one of those specific places, then any person in Colorado was authorized by the governor to kill and destroy you and to take all of your property. That's why I don't like playing on the field of the law, even though I'm a law professor and I'm a lawyer by training. That's why I'm critical. We start with the US Constitution, we start with the dominant society's laws, then what legitimacy are we accepting? Are we accepting the legitimacy of these types of executive orders? So what happened at the Sand Creek Massacre was there was a peaceful camp of Cheyenne and Arapaho that were camping at the place where they were supposed to be camping. There was this executive order that said you have to go to these places or we'll kill you. So they went to that place and they flew a white flag of surrender, and they still got attacked by the army, and 300 something people got murdered, 2/3 of whom were women and children. So again, that's the context of these treaties. And that's the thing I think that, again, that I don't want to get left out. You sit down and you read a treaty and you just read it in black and white and you're looking like, what do these words mean? You are going to forget, you are going to omit, you are going to just jump over the fact that these treaties came because there was this huge battle of 1,000 warriors charging up against these cannons that are being fired at them, and then they are repelling out Kit Carson. And so then 4 days later, literally 4 days later, a different group of the United States Army goes to other Native Americans that are sitting there totally peacefully with a white flag and just massacres all of them. That part is not just shown. That didn't make it into the text of the treaty, which is why I think it is important not to just focus on the text of the treaty, but to focus on the history of what is happening. So October of the next year, they get all these tribes together at the Little Arkansas, and they sign these treaties. There's two treaties of the Little Arkansas, 1865 treaties. Again, this is not how these treaties are not what I would call charity. And I think that's why I'm going over this history, is because I think in the 2024, where we don't have warriors the way that we used to, that have, you know, horses and are going to ride up against these howitzers because those warriors from 1867 agreed to surrender. Because we don't have that anymore, I think sometimes we have this idea that the states or the United States is just giving away these treaty rights as some type of charity. Like, oh, we're just, you know, we feel bad for these poor, pathetic, pitiful Indians. We're just going to give them this little, you know, here you go. And that's not what these treaties were about. These treaties were about, like, oh my God, we have a huge problem. We have all these wars, and we're trying to kill these Indians with these huge cannons, and we can't even do that. And the only ones that we can even, you know, the only ones that we're killing are the ones that are being peaceful. We're just coming in and slaughtering them. You know, can you imagine? Just put yourself in the mind of the United States. Like, oh my God, we just lost this huge battle, and then 4 days later we massacre all these people. Like, if you are a United States policymaker, you got a problem, right? You have a problem that you have to fix. So this isn't charity, like, oh, I'm just giving this away. It's like, oh my God, there's this huge problem. We're having these wars. They're getting very bloody. There are all these civilian casualties. There are these women and children that are getting killed. Our best Indian fighter just got routed, even though he was way out arming everyone else. So this isn't charity. This is the United States saying, like, okay, we got to end these wars. So we're going to give something significant. We're giving something substantial, not because of charity, but because of necessity. They signed those treaties. 2 years later, there's another war in Kansas because, again, the army comes and burns down a Cheyenne village to the ground. This one had been vacated already because, you know, obviously they had seen what was coming and they left the village before they were massacred again. And so this continued conflict leads to another set of treaties with all of these same tribes in October of 1867. And these are the treaties of Medicine Lodge Creek. And the one with the Kiowa and Comanche came first. Again, then later that same day, the Apache joined this treaty. And then 7 days later, the Cheyenne and Arapaho had their treaty. But it illustrates, I think, a couple of very important concepts. And the first is like what I've been talking about is this trust relationship. The very first article, Article 1 of this treaty, is a promise of peace. The very first sentence of the treaty is, from this day forward, all war between the parties to this agreement shall forever cease. So those warriors, these brave men, courageous men that fought these wars, protected their women, children, elders, they are saying to the United States, okay, we're agreeing to lay down our weapons, but they're only agreeing to that because of everything else in that treaty. They're not just saying, oh, we surrender because we're outnumbered. These are men, again, that they fought away. They fought Kit Carson armed with 2 of these. So they're coming and they're saying, we are going to lay down our weapons for all of the rest of the rights in this treaty. Some of those rights are that they will, the first again, and then it goes on, after they have this promise of peace, it goes on and it says that all of their warriors promise they will not retaliate against any bad men. It says bad men among the whites is the actual wording, but they will not retaliate against non-natives, but instead report them to the Commissioner of Indian Affairs. So they're essentially just waiving their right to self-defense. And in exchange, the Indian agent is agreeing to faithfully discharge his duties. So this is essentially, not in so many words, but this is the trust relationship, right? The United States government is agreeing our Indian agent will faithfully discharge his duties. And so again, if you just focus on the text and not the context, you're going to look at this treaty and you're going to be like, well, this doesn't say anything about the trust relationship. Where is the trust doctrine in this treaty? It doesn't have it in the plain text, but it has it in the context. You have these people that are agreeing to not fight, not wage war anymore in exchange for the United States to faithfully discharge its duties. And there is similar language, and again, I don't want to tell the story of other tribes, but there is similar language in a lot of these treaties. And it goes back, and this is what even the Supreme Court has said, if you go back to Cherokee Nation versus State of Georgia, like similar language to this is what created the trust relationship. And in particular, in that case, Chief Justice Marshall noted that they, mean Native American tribes, look to our government for protection. Article 2 establishes a reservation. And that was the fundamental point of the entire conflict, right? Was that there were settlers coming in, and then that was already the territory of all these other tribes. So they were trying to expel these settlers. And so creating a reservation is supposed to solve that by saying, number one, removing them from that area where the settlers are coming, and then the promise of the government that there will be no settlers in the reservation area. And they use, again, they don't spell that out in so many words, but instead they say only authorized, quote unquote, other people are able to be on the reservation. The other articles of this treaty go into what I guess today would be called economic development. But in these other articles, the United States offers to do things like build a sawmill, provide an engineer, provide a blacksmith, provide a school, provide a physician, clothing, pay annuities, encourage farming and agriculture by giving heads of household land, giving them implements, giving them training on how to become farmers. And then one thing I thought that was very interesting that hadn't even stood out to me the other dozens of times I've read this treaty, but for whatever reason stood out to me when I was reading this a few weeks ago, is then in Article 13, it says the Indian agent in employing a farmer, blacksmith, miller, and other employees herein provided for, qualifications being equal, shall give the preference to the Indians. And so the reason this stood out to me is that today we have things called tribal employment rights ordinances, TARO. Even in the BIA, they have these things called Indian preference, tribal preference. And you see those sorts of things coming under attack so much in 2024, where we have these controversies about things like affirmative action. Like, should tribal members be given some sort of preferential employment, or should they be given preference to be admitted into these schools? That's reverse discrimination. That's anti-American. That's this, that's that. Well, you know what else that is? That's a treaty right dating back to 1867 that was, again, fought for, died for. And so if you just brush it aside and say that's reverse discrimination, that's an insult to all those people that gave their lives and all the other ones that surrendered specifically to have this sort of right of preference in employment. Article 12 talks about significantly how that treaty can be changed. And it says 3/4 of the adult men have to agree. It's not quite as long as the sunshine and the grass grows. That's language that sometimes you find in other treaties. There's some Comanche treaties with the Confederated States during the Civil War that had similar language to that. But it's specifically saying this is how this treaty is going to be changed. And to me, again, that's significant because you have these warriors that are laying down their weapons. They're saying, okay, we will give up our weapons, we'll give up our right to self-defense, but if you change this treaty, you got to get 3/4 of us to agree. And this was the very first thing that went out the window. Not even a generation later, the 1890s, 30 years later, less than 30 years later, you have the United States come in and they say, we are going to have this policy of allotment. And we are going to give the heads of households 160 acres, and then we're going to give all this other land away to these settlers. So totally contrary to the entire purpose of the treaty that I mentioned before, was to have this peace to separate the tribes from the settlers. They're saying, hey, we're going to bring in more settlers. We're going to allot this reservation, and we're taking 2 million acres for the government. So because of this treaty, the government at the time felt like they needed to get 3/4 of the Dalt Mill signatures. So they sent these guys out into the communities and they got 456 Dalt Mill signatures, which they claimed at the time was more than 2/3. There was a couple problems with that. First problem was that a lot of those 456, most of those 456 later complained, we didn't know what we were signing. You got our signature by fraud. You sent an interpreter over to me. He talked to me. He said this was something else. So I signed it. And then I later found out you're trying to take away our reservation. That's fraud. Even worse for the government is that not only did they defraud, but they didn't even get the 2/3 because there was later a census that showed that 456 was in fact not 2/3. So they don't have the 2/3. But Congress goes ahead and allots the reservation anyways. Lone Wolf was Kiowa, challenged this. It went all the way up to the Supreme Court, and the Supreme Court just said, well, that's part of the plenary authority of Congress. And so that's the plenary power. Congress can do whatever it wants. It can abrogate these treaties. Never mind. And then there was no consideration at all given to that trust relationship that I was emphasizing a moment ago. No consideration given to the context that here all these people fought and died, and they only gave up on the promise that that would be a treaty until 2/3 said that it wouldn't be. They just throw it right out the window. So after Lone Wolf, that's what we've been dealing with. I think Lone Wolf was in 1906. Don't quote me on that. I didn't double check right before I started talking, but I'm pretty sure it was 1906. So now we have almost 120 years of precedent in the United States that Congress can just abrogate treaties, which again is why I reject starting the conversation about treaties with the US Constitution, because I reject the legitimacy of a system that says Congress has the plenary power to just abrogate treaties whenever it wants. So don't do that. Don't rely on these legal doctrines. Don't view these treaties as a kind of singular thing. That's the other thing that happens a lot, is they say, and this is something I've run into a lot, because before I was the tribal chairman, as Dr. Tomakera mentioned, I was also the tribal attorney. And so one thing we ran into a lot was just, oh, well, you're Comanche Nation, you're saying you have a treaty right. There's this Lone Wolf case that said your treaty was abrogated. So you don't have any, your treaty is null and void, it's nothing. And that's not how you're supposed to interpret them, even under the US legal system's concepts of treaties. There's supposed to be different rights, and you only interpret it to have abrogated the right that was at issue at the time. So it gets all very technical. McGirt, actually, that case was all about that particular point, was that just because you allot a reservation doesn't mean you diminish a reservation. Those are two different things, and you need to look at each stick in the bundle of sticks that makes up the rights of a treaty individually. But even though that's a case from the Supreme Court like 2 years ago, and even though there's a whole couple centuries of history, you still run into the case that there's judges, most of them probably out there, that just look at it as a one and done, because that's how they would look at contracts. If this contract was, declared void, then the whole thing would be gone. So, oh, this treaty was declared abrogated, the whole thing's gone. And that's not how we should look at it, but that's how it does. That's how it happens. And because all these treaties are being held to be abrogated, the consequence of that is that the United States has started to write down a lot of the treaty rights in statutes and regulations. So like that employment preference I mentioned a moment ago has made its way in to the Bureau of Indian Affairs regulations. The right of the Comanches to have a physician paid for in its treaty, and the rights of other tribes there are similar provisions providing a physician for them in their treaties have made their way into the Code of Federal Regulations under the guise of the Indian Health Service. The provisions of the treaty that say that the Comanches get a school has become all the regulations for the Bureau of Indian Education and the schools. So that's, on the one hand, that's positive, like it's good. I'm glad that IHS exists. I'm glad that there's BIA employment preferences. I'm glad that there's schools out there. But when you make it a matter of regulation and a matter of statute, you're putting it down here. You're not elevating it to the status of a treaty right. And that's why I think the conversation so often then just becomes, oh, these Native Americans, they get IHS, that's preferential, that's special treatment, that's unfair, that's reverse discrimination. And that's the sort of conversation that happens because we're talking, in my opinion, because we're talking not about treaty rights, but we're talking about regulations. Oh, and the government can't treat people unequally. If there's the Indian Health Service, there has to be non-Indian Health Service. No, because it isn't truly a matter of regulation. It's a matter of these treaties, and only the people that had their ancestors that fought and died to get these treaties should get the benefit. That is our birthright. If people get to inherit, you know, something from their grandfather or great-grandfather, in most circles, we don't question that. But for some reason, when it comes to treaty rights, then all of a sudden the dominant society starts to question it quite a bit. And this manifests itself in another thing that, again, has become quite a big pet peeve of mine as a tribal leader, is so often we go and we consult, because there's all these consultation requirements. We go and consult with local governments, with state governments, with the federal government even, and we say, you know, we want our tribal members to have access. We want our tribal members to have access over there because we want to go do a ceremony over there. Or we want to have our tribal members access so they can go gather medicine over there. Or we want our tribal members to be able to go hunt over here. It's the conversations I've had. I've only been doing this for 6 months, but I had a lot of these conversations. And they say, well, why do you want to do that? Well, because our treaty, you know, that's part of our treaty area. We have, our treaty mentions hunting. We have hunting rights. Our people, they had ceremonies over here for a long time. We want to go and we have ceremonies. This is all part of our treaty area, or we're supposed to have, no settlers are supposed to come without our permission. This is part of what we want. And then the response is always, oh, well, if we let Greg Cole go over there, we got to go let John Doe go over there. If we let Forrest go have this ceremony over here, then, oh, we got to go let every church that wants to do this. If we open up the hunting to you, then we got to go hunting to the whole public. The public is going to have access. We got to treat everyone equally. No, you don't. You don't have to open up a sacred site to every church in America because the Comanche Nation wants to hold a ceremony there. No, you don't. You don't have to open up some, protected area for everyone to go and gather plants just because you let a couple Comanches go over there and gather. You don't have to open up hunting in an area to everybody just because you had a few Comanches go hunt there. We have a unique status that is members, citizens of a government that entered into a treaty with the United States. And that is very unique. And just because other people don't have it doesn't mean it's reverse discrimination. Again, those rights were earned the hard way. And that's basically what I had on the slide. Lumping in tribal members with the general public diminishes the sacrifice and courage of those warriors that literally stood up to howitzers armed with nothing more than rifles and bows and arrows. I have just a couple minutes left. I was hoping to have a little time for questions, but kind of talked a long time. So I'll just wrap it up with this. This manifests itself in so many different places where I think the government doesn't really appreciate the true significance of the trust relationship viewed through the eyes of Native Americans. You look at something like anything that touches on Native Americans, like the missing and murdered Indigenous people crisis, like that is part of the trust relationship. That's part of the United States not holding its end of the bargain. There's those treaties that say that if there's bad men, they're supposed to hold them accountable. but there's no accountability in the murdering of missing indigenous people. There's no accountability when it comes to intellectual property, which again, that was my area. If you heard Dr. Tomic here's introduction, that was my area of scholarship when I was a law professor. I'm on leave right now because I'm a tribal chairman, but that was my area, and you saw it all the time where you have all kinds of cultural appropriation, misappropriation, and there's this there's even this World Intellectual Property Organization is trying to get these treaties between these countries to address this issue, and the United States is just kind of like, consultation, smonsultation, trust relationship, whatever. And so even when it's the state, like we have all these disputes with the state, whatever it is, tobacco taxes, tribal tags, criminal jurisdiction, everything, you have the state digging in, refusing to negotiate in good faith. What is supposed to happen in there? The federal government is supposed to step in and help resolve those disputes, but it just steps back and does nothing, and it's just lip service. So I'm out of time. I could talk about this for a lot more, as you can probably tell, but I appreciate everyone's attention to what I've been saying. But fine. Thank you.
Thank you so much, Chairman, for sharing your perspectives on tribal treaties and tribal treaty rights. I think, to me, acid to the wound is that Native Americans weren't considered citizens until 1924. So when you hear about these obligations of treaties, we didn't even have a way to sue. So talk about major stiff arm on a lot of these issues. And for those of you who have attended or in the future attend the Tribal Engagement 101 that I give, I briefly, in 10 minutes, walk you all through 200 years of policy eras. And I tell you how important it is to put yourself in a tribal leader's shoes, because every single day they have to make decisions on the legacy of those eras, as Chairman Tadanipa prepared or shared with us today. And I also demonstrate to you, and it was demonstrated today, and illustrated about the complexities and how complicated it is. So thank you again. Another round of applause to Chairman. Thank you. For those of you who would like to hang out in person, Chairman will stick around for a little bit for any questions you might have. And before we sign off, I want to acknowledge a couple of people. Evelyn Cox in the back, she's our Native Nations Center Research Project Manager. We have Juana Yazi, the Native Nation Center Office Manager and Brand Extraordinaire for Native Nation Center. Out in the hallway, we have Grace Harris, who's a Native Nation Center intern, and she's also a Mellon student scholar in the Native American Studies Department. Thank you all for your candid effort. And last, I'd like to acknowledge Joy Penley with the Center for Faculty Excellence. Thank you so much for your support for these ethical. Last note, for those of you in person, please stay. You can see the poster boards up. We are doing an ethical tribal engagement faculty showcase, tribal partnerships in academia. It's on this floor, and it's down in the Five Minutes Lounge on the first floor. And stay tuned for Native Nation Center programming in the spring. We're going to be hitting on the ethical tribal engagement 101 that I mentioned. And also, I'm so excited for an AI and tribal issues panel that we'll be hosting on OU Tulsa campus. Thank you so much.
So